All right, so looking at school prayer, what we want to do here is, let's talk about just school prayer in general for a second. All right, liberal people that are Democrats, so someone that might be on the Supreme Court that was appointed by a Democratic president. How, in terms, general terms, do they feel about school prayer or prayer in school? Are they for it or against it? Against it. All right, so typically speaking, Democrats are going to be against this. All right, Republicans are what? All right, so we get that. All right, so if I was going to interpret the Constitution strictly here, all right, dealing with school prayer, I would interpret the Constitution looking at this based on what? Okay, so how is school prayer written in the Constitution? Is it? Okay, so we have to dig where? Where in the Constitution are we going to dig for this information? Okay, the Bill of Rights. So specifically what amendment? Right, the First Amendment. What does the First Amendment say? All right, so you have the right to freedom of religion. All right, so if I'm a strict constructionist, all right, I'm going to say that the Constitution says that you're free to choose religion. All right, so that means that I feel that school prayer is okay because you're allowed to choose religion, all right, of your choice, whether you want to take part in it or not. All right, someone who's against it, so a Democrat or a liberal person, liberal ideology, might argue this idea of loose. All right? So if they're arguing this loose interpretation, what are they going to say about it?
It doesn't say that you can't pray in school.
Okay, so it doesn't say you can't pray in school, 1. 2, what else? What?
Affects other people's First Amendment.
Okay, so it affects other people's First Amendment. All right? All right, so it affects other people's First Amendment. Is there anything else?
Isn't it like a state thing?
States' rights, maybe?
Because schools are under the state, so separation of church and state would apply.
Okay, so maybe this idea of bringing in separation of church and state. All right, so yeah, that would be a good point too. So this is the loose, and then this is the strict. All right, so do we understand this so far? Is there any questions on loose constructionists versus strict constructionists? All right, this is a very large part of your grade on the project. All right, we have a judicial branch project that we'll be talking about tomorrow in class that will start on Thursday in the library and finish up on Monday. All right, so we'll be there for 3 days. All right, so if you don't understand this now, we need to fix it and get you to understand it. All right, is everybody good on it? All right, so next we're going to talk about how justices use strict and loose constructionists to influence their writing. All right, how do they write an opinion on a case? All right, well, there's 2 ways to do that. All right, the first is this idea called a living constitutionalist. All right, so if I'm a living constitutionalist, when I write about a Supreme Court case, what I'm doing is I'm saying that the issue would involve or change or adapt to circumstances without being formally amending. So what I'm saying is that it's possible in my writing for me to branch out and find other things outside of the Constitution to include in my argument without technically formally amending the Constitution itself. All right, so pulling from other documents of historical background, etc., as well as saying that over time things have changed. All right, and so that we have to take into account that in which we write about it. All right, an originalist is the idea that it is the principle of interpretation that views the Constitution's meaning as fixed as the time of enactment. So this is this idea that's saying that however the Constitution was written, when it was written, signed, drafted, and finally became law and enacted, that's how we're reading it. We're not talking about everything else. All right, and this is how Gorsh, the guy who's been tapped to replace Scalia, this is his judicial writing style, is an originalist. All right, so when we're using this to write, all right, someone that's a living constitutionalist might use this idea that City mentioned a minute ago in the separation of church idea. All right, separation of church is not listed in the Constitution. It's actually found in a letter from Thomas Jefferson to another important person in history. It's also noted in a footnote of a dissent of a judicial paper. All right, so it's not actually found anywhere in our Constitution. So this idea of it's really, instead of being separation of church, it's really called a wall of separation. All right, and so this wall of separation would be something that a liberal or democratic justice might use to argue their ideas that school prayer violates different people's beliefs. All right, and so they would be using this idea of separation of church or wall of separation to argue their living constitutionalist point of view. All right, an originalist would again go back to the Constitution and say, well, the Constitution clearly states that we have this right to freedom of religion, and therefore it's there, and then again, therefore, you have free choice to take part in it. All right. Now, it's possible that on certain cases you might see the entire court rule 9-0 on a case, all right? Well, obviously, their ideology didn't match up on that case. All right, they didn't rule how we think they should have. All right, they ruled because there's something in that case that stood out to them that all of them were in favor for. Or you might see a case where they rule, all against. Or you might see cases where judges flip their votes, that they were appointed by, a conservative president, but they tend to interpret the Constitution liberally. They interpret it that loosely idea, and they write living. It's possible that it can flip any which way. So be careful when we begin looking at these things that we aren't getting zoned in, well, they're conservative, so that means they have to rule this way. It's possible for them to change. It's possible for them not to be the exact way. It's just like us. We might identify as a Republican. We might identify as a conservative. We might say that we're socially liberal and fiscally conservative. All right, you might say you're moderate. All of us aren't going to agree on everything. We're all going to have different opinions on every single thing. just like these guys do. All right, they're human too. We have to remember that. All right, so there are any questions on this? All right, so what I'm going to do is we're going to get us in some groups here in a second. We're going to practice with some cases. All right, but before we do that, what I want to do is I want to go over with you the justices at the time for the cases we're going to be using. All right, and I'll leave this up here. All right, so ideology for the activity. All right, Alito, he's going to lean right. All right, so conservative. Breyer, he's going to tend to lean a little left. Ginsburg is definitely going to lean left. Kennedy is going to be a swing justice, even though he was appointed by Reagan. All right, Roberts is going to lean right. Scalia leans right. Souter leans left. He was a Bush appointee. Stevens, early on in his career, was a very conservative justice, but later on, while serving on the court, he begins to lean left, and that's where he'll end up in history, is what he did towards the end of his term on the court. And he's a Ford appointee. And Ford wrote a letter back in 2005 saying that he supported Stevens today, and that he was thankful that he put him on the court. And then Clarence Thomas leans right. All right. So, like I said, I'm going to leave this up here. I'm going to get us in some groups here in a second, and we'll go from there.